Hi, I'm attorney Gregory Dell, joined by attorney Alexander Palomara, and we're going to discuss one of Alex's success stories against Mutual of Omaha long-term disability insurance claim. And Alex, in these cases, we like to talk about the background and history of the claim, the policy language, what you were able to do to achieve success on behalf of your client, and then provide some tips for people who may have a Mutual of Omaha disability claim. So give us a little bit of history on this claim.
So my client was in the computer industry. He worked for a reputable IT service supplier, Nexus Tech, a pretty well-known company. He worked as a help desk engineer, basically just helping people with their computers and IT issues all day, every day on a regular basis. Suffers from carpal tunnel, which is tough when you're using a mouse or a keyboard all day. But carpal tunnel, back issues, neck issues, neuropathy, just in pain a lot of the time, all day long, I should say. And fortunately, his employer provided its employees with coverages under short-term and long-term disability insurance policies. And what the crazy part is, he didn't come to us until he got denied benefits. And he thought actually it was going to be a pretty easy transition to go from short-term to long-term, because short-term was improved the entire time period. And the insurance company said, we find you disabled for the full 3 months of short-term disability. He thought he was going to be a smooth transition right into long-term disability benefits. But lo and behold, what we see on a regular basis is that the insurance company somehow magically thinks at the stroke of midnight, when short-term disability ends and long-term disability is set to begin, he gets denied benefits that day, gets a denial letter in his mailbox, and can't believe what's happening. And fortunately, he found us. And fortunately, we're able to get him on claim.
So Mutual of Omaha approved short-term, then denied the long-term disability claim.
Correct. And the crazy part is, it wasn't like one day they sent him a letter and he got message that next morning that his claim was denied. Even after short-term disability ran out, they reviewed his claim for a few months before they actually issued the long-term disability denial. So he was kind of in limbo for about a 2-month period, which I always try to prevent that from happening with my clients because I don't want them to ever go without any benefits. So I make sure that we apply for long-term well before the transition date and make sure the insurance company has as much information as possible. But lo and behold, they took their sweet time in denying this claim. And the craziest part about it, so not only was short-term paid the entire time period, but Social Security disability benefits were awarded while they were reviewing the claim. So it's like you have one part.
And they knew about that.
And they knew about it. 100% knew about it. So they have short-term disability being approved. So one part of the insurance company is saying he's disabled, Social Security is saying he's disabled, but the long-term disability people saying that he's not disabled and denying the claim. Just didn't make any sense whatsoever, but he found us and we were able to get him back on claim, or get him on claim.
So that's incredible that the Social Security was approved and they knew about it and they still denied the long-term, but what was the basis for their denial?
So essentially, one of his doctors filled out an attending physician statement that stated that he could return to work with accommodations. It was a very bland letter that the insurance company, what they should have done is ask for clarification, what the doctor meant, like what kind of accommodations would allow him to return to work. But they took with it, give him a yard, they take a mile. They took it with it and they ran and they used it as justification for denying the claim. They had a review done by an in-house doctor who said, he has the ability to sit at his job all day and do his job. I don't even remember seeing an intricate look at the requirements of his own occupation. I think they just looked at it as a sedentary job, but I don't think they took into account the fact that, he has to use his brain all day as a computer engineer, and he has.
So his job required the use of brain.
The use of brain, very unique, but he's a good earner. But but sometimes they say if you can sit there, you can work.
No, absolutely.
But the problem is you have to be able to concentrate. If you're dealing with pain all day long, or if you take pain medications to prevent that pain, there's just no way you can concentrate and do the high-level computer work that's required, or whatever kind of work people do. You can't just sit there in pain and expect the people that can do work all day long. Pain is very distracting.
So pain is subjective, and by that we mean there's no exact MRI, X-ray, or test that's going to verify whether or not someone has pain. I mean, someone could see something that one person looks at and says is painful, and another person looks at it and says, I can't believe you're not in pain. Right. So how did you go about proving not necessarily the medical issues he had, but that the pain he was suffering was disabling him?
Well, you have diagnostic measures to prove that his complaints are real. You might not be able to prove the level of pain. There's no blood test to show he's suffering from 9 out of 10 pain. But there's other objective measures to show that he has these conditions that should be causing pain. So when you have MRIs and X-rays to show damage to his back and neck, that's the way you show that his subjective complaints are likely real. Before we filed the appeal, we also did a functional capacity evaluation. So we sent him to a physical therapist to show that he didn't have the physical capabilities of doing a sedentary job. So we had a physical therapist run him through a couple of hours of exercises to show what his abilities and inabilities were. And the independent physical therapist, who I've never met before, we found him to work on the claim. They said that he had a less than sedentary occupational standard. He could not even do a sedentary job on a full-time basis. So we realized that. We realized the fact that Social Security, we got a copy of the Social Security Administration's claim file, and we got updated objective evidence, updated reports from the treating providers, and we got the doctors, his treating providers, to fill out attending physician statements, which all stated that he did not have the current ability to perform his job or any job. So we put that all together with an appeal, and thankfully this appeal was successful.
And so when you did your initial claim in the appeal, it was an own occupation definition of disability.
Correct.
And are you going to be, does he have a different definition of disability that will be coming at some point in time?
He does. So the claim is pretty darn new right now, so we
Okay.
haven't got to that point. Under this policy, there's what's known as a change in definition of disability. So for the first 2 years, in order to get benefits, you have to prove to the insurance company that you're disabled from your own occupation, which in this case, is a sedentary job. But going further, to get benefits beyond 2 years, in order to get benefits, you have to prove to them that you are unable to perform the duties of any gainful occupation. And the way that's kind of defined is that it has to be a job that has to take into account your training, education, and experience, and there's an earnings requirement. In this sense, it's a job that pays him 60% of his prior monthly earnings. So he's making 10 grand a month previously, they have to find him a job that's going to pay him 6 grand a month, that he has the capabilities and physical abilities to do. So it's going to be a fight on our hands because we know that's when the insurance companies love to deny claims. They love to deny claims at the 2-year mark. So right now we are basically prepping for a battle. We're trying to prevent a war just by giving them as much support for the claim as possible, just so that maybe we can have smooth transition where there's no denial. That's our goal, is having no denial. And so we are building this case up on a regular basis to prove to them that there's no reason for them to deny this claim.
And how are you building the claim up?
Updated objective evidence. So we need our client to always be seeing their treating providers. He's continuing to see his treating providers, and we're getting objective, even though the doctor sometimes thinks it's a waste of time, that it's only been 6 months or a year since his last MRI. There's no reason for it yet. I go, doctor, we just need to have proof of this claim to show that he remains, that his back issues remain, that nothing's healed back there yet. So we do updated objective testing, updated medical records, updated letters of support from the doctors to continually show that he's disabled. Sometimes it seems like overkill, but you have to do it.
And was there anything in a vocational review that they did that's something that you're going to have to contend with as well?
They've not done one yet, as far as I know. And the problem with these claims and the ERISA laws that govern the great majority of these claims is that they don't have to provide you any documentation until they deny your claim. Right. So you kind of have no idea what reviews they are doing right now, or what the results of those reviews are, or if they're doing a vocational assessment to see what the requirements of his job are, what the requirements, they think the requirements of any occupation are, what other jobs they think that he can do. You don't get it until they deny the claim. But that's the keys. The key is to keep on killing them with proof of your claim, so they have no choice but to keep on reapproving your claim.
And the other thing that people should not necessarily feel comfortable with is the fact that even look in this case, which is a great example, he was approved for Social Security disability. Even out of the outset, one of the soonest I've ever heard of
Really
approved
fast.
for Social Security disability. So people think, oh, I have Social Security disability, I'll just tell them that and they'll accept it. But 9 out of 10 times what they say is, well, their standards are different than us, they look at stuff differently, and we want to look at it on our own, which they have the right to do. So they don't take that into consideration as having a lot of weight, and they're not required to do so by law.
Right, they have to review it, but they always discount it. And the crazy part about this case is that they said we have more updated information than Social Security did. And it was really 2 months prior. Like, what updated information do they have that he magically got better in those 2 months? It was kind of a lack of a better term, a BS excuse for overlooking the Social Security approval.
Well, luckily you'll be there to protect him, and I know you're gearing up for that change in definition, and hopefully they won't change it to somebody else, because that also is another thing that turns into a situation where the claim's denied. So it'll be interesting to see what happens, but I know he's in the best position possible to keep his benefits continuing for as long as he wants them. So if you're someone who has a Mutual of Omaha long-term disability insurance claim, feel free to reach out to Alex, myself, any of our disability lawyers. No matter where you live in the country, we're always going to provide you with an immediate free phone consultation, and we're available to help you no matter where you live. Hi, I'm Gregory Dell, the managing attorney of Dell Disability Lawyers, and I hope you find the video you just watched helpful. We put these videos out all of the time, and we'd love if you would subscribe to our YouTube channel. Beyond our videos on our YouTube channel, we also have lots of information available on our website at diattorney.com, and we encourage you to come to our website. The goal is that we want you to be educated about the disability insurance process, and when you get to our website, you'll see that we have information all about your specific disability insurance company, your occupation, and your medical condition. And we've designed our website such that you can easily search our website to find things that you may specifically be looking for. Now at our website, we have thousands and thousands of pages of information, hundreds of videos that you can search, plus we're building a section of reviews of all the disability insurance companies, and we have the Ask Our Lawyer section where you can go ahead and ask us any questions that you may have. Now we realize that you may not need us right now, but you may need us in the future to help you with your disability claim, and we think one of the best ways to keep in touch is by clicking the button below and subscribing to our channel. And most importantly, again, no matter where you live in the country, we're always available. Just go ahead and give us a call. We're happy to discuss your claim and let you know immediately if we can help you.